basis that our client Vodacom Group, based in South Africa, is not a contracting party. The actual purchaser of shares, my lord, is Vodafone Kenya Limited. So if you are allowing an oral application to add the correct purchaser,
we have not allowed it.
I am just saying that they must be looked at together, because actually the oral application to add the correct purchaser is inherently accepting that our strikers application is indeed well-founded.
So you are supporting the application to buy Vodafone and remove your client?
They are saying, give us direction so that they are added together, not today orally, without an affidavit in support. Let them put in their evidence, give us direction, then we come back to you, and everyone else can participate. So the first thing is we cannot deal with this orally.
Yes.
The second,
or what we have said.
Yes. So the second is to note that we already have 10 respondents to these petitions, my lord, so that we are careful when we are adding or removing to have the correct citation. So it's just something I point out so that we don't get ourselves further confused. Then the second oral application before you is to grant leave to amend the petition. We were told by senior counsel to correct a few issues. We do not have a formal application before this court that allows the parties to respond to it and to take instructions as to what are those issues and whether or not they should have been canvassed earlier, given that this petition, this specific one, E051, was filed in January, and we're now in April. But it is only to point out from the submissions made by the Petitioners' Counsel that these few issues do not appear either minor or non-material, and therefore they are deserving of a proper formal application and court scrutiny. And the reason I say this is because if the amendment of a petition is to add a party that is currently not before you, that is a material and substantive issue, number one. Number two, if it is to add, for example, as we have had, an issue to do with the IEBC and the election regulations, again, those cannot be classed as a few issues, because that is probably going to significantly change the nature of the issues before you today. So as we stand today, we came ready to meet the petitions that are before this court. There are 3 petitions, and we would urge the court not to disadvantage the respondents by allowing us to be ambushed by oral applications. And then there's a final point, my lord, I have to make, because I think I've been accused of bad faith, and my colleagues.
We sorted out that issue.
No, my lord, I will have to respond, because senior counsel said, and he repeated, that eventually when this matter is canvassed on the merits, there would be other and deeper arguments, including the sale of shares to a foreign entity. And then he emphasized it by saying, and I repeat, a foreign entity. But my lord, that is a gross misrepresentation of facts, because the purchaser of the shares is Vodafone Kenya Limited. It is an existing shareholder, and it is a company incorporated in Kenya. And they will show you this because they want to file a CR12, my lord, in support of the application. So their CR12 will confirm what I'm saying to you. It is a Kenya company. So when senior counsel misrepresents and say this is a sale of shares to a foreign entity, and you have reminded us we are a court of order and a court of law, I must object strongly to this mischaracterization. I think it is meant to make you scared as Kenyans that you are losing something. I think I need to remind you that Vodafone Kenya Limited has been in your journey along the way and is not new to Safaricom and is within very much the jurisdiction of the Kenya court and is subject to all Kenya laws. So we would ask you for our directions, my lord. Thank you.
Anybody else?
Yes, good afternoon once again, my lord. My lord.
Can you took 3 minutes?
That's fine, my lord. Your Lordship, I represent Vodafone Group PLC.
That is Mr.
Ismail, you can record your Lordship. ESMAIL. Your Lordship, I think it's important for housekeeping purposes to point out, as Mrs. Abdallah has adverted, that when the petitions were consolidated by your brother Justice Mugambi, Your Lordship, there were 2 petitioners whom Mr. Lempa represents, and then there were 2 other petitions filed by unrepresented parties. And we took the liberty to consolidate all of them and put the respondents down. And my client, Vodafone Group PLC, is the 10th respondent in the consolidated petitions, Your Lordship. I will make 2 points, none of which touch on the arguments that have been made before Your Lordship and my ladies. And those 2 arguments are as follows, my lord. Firstly, the petitioner...
Yes, where is my neighbor? Is the fellow away? He's judging.
Yeah, Your Lordship, I think it is important to point out that the petitioner who cited my client as a respondent is actually not interested in his petition at all. He is not present in court today, Your Lordship and my ladies. And for that purpose, Your Lordship and my ladies, they have not even responded to the submissions filed in support of our preliminary objection, which is dated the 4th day of February 2026. And I believe Your Lordship and my ladies have had an opportunity to look at the substance of that PO. It is simply seeking to strike out my client from these proceedings. So Your Lordship and my ladies, I think my client's position is that we are not parties to the transaction and are not affected in any manner by the dispute between the parties. So Lordship, to continue to occasion costs on my client to sit through these proceedings, whilst the petitioner first is not interested, and secondly, service was not effected as per the CPR, as well as the fact that there is no nexus between the allegations in the petition and my client, Your Lordship and my ladies, is the principal are the principal reasons on which we ground our application to be struck out. So Lordship, cognizant of the fact that the current contestation is on the issue of potentially conservatory orders, as well as the other issues that have been brought before the court, we would be urging Your Lordship and my ladies to give us directions in respect of our PO at the appropriate time, my lord. Thank you, my lord.
Just one issue. Paragraph 45 of the ruling. Mr. Maro. Yes. Yes, at paragraph 45 of the ruling.
Paragraph 45 of
The ruling dated 23rd March 2026.
the court was addressed recommended that this court
May have to consider other aspects of preliminary questions that might have considered. So we also be seeking directions on the PO that we filed. The AG filed a preliminary objection dated 17th March 2026. So we will also be seeking directions on that.
yes.
A concept is given for us. However, I heard Mr. Maga objecting to this joint. Yes. And they say that they would object. Now, I need to bring to their attention, Rule 7 of the Junior Rules gives you the leeway to enjoin us so much. I think they need to look at that rule once more. With respect, the owners and the drivers of the petition.
Suomoto under rule.
7. Rule 7. Of the Junior Rules. You got notice 117 2003. Yes. Number 1. The joinder, I suppose, was made, the door was open. Good morning, Honorable His Excellency. The law is saying you don't object to our application. And therefore, the issue of the opposition, in my humble view, does not arise. Therefore, the owners of the petition have said come on board. And therefore, now looking at the discretion you have, totally unfair. Totally unfair. Not even conditional. And Ms. Ohaga said, the Supreme Court has said an interested party should be enjoined because they made use of that. Rules made pursuant to the Constitution. Legal Notice 117 of 2003 states, Rule 7, you have unfettered discretion. Having said that, it is my client's interest, therefore, to have the subject alive for adjudication with the status quo order in place.
I think we joined.
Yes, my lord, but I'm saying,
Don't argue anything substantive.
yeah, but I'm not arguing substantive.
Yes.
I just want to bring a point of law. Because of now, if my client comes on board after the horse has bolted, this will
No,
be
we
exercise.
consider these applications before we hear the petition.
Yes, but I'm saying,
And I was going to come to those particular applications.
yes,
So we were listening arguments in respect of status quo,
yes,
and then we go back now to the specific applications and give directions.
yes, I wholly agree. But I'm saying, my client to them, because we filed an application first, before we came here, and that application had been served for notification to everybody, and I received communication from Mr. Len that he was not objecting, he would in fact consent to the joiner, which he did.
Yeah, the petitioners are not objecting.
Yes, yes, yes,
We have no problem with that.
yes,
Except now, Dr. Haga,
yes,
I'll give directions in respect of that.
yes, but I need to close by saying,
Yes.
Your Lordship,
Yes.
if you let the horse bolt, in other words, you don't extend the status quo.
I'm on you, Harrison.
Yes.
Don't argue anything substantive.
But that's not substantive, my
I'm
lord.
giving you that,
I'm saying, no, hold it. Now I interrupted you. Now I interrupted you.
Harrison, I'm the one who is telling you.
Yes, but they are raising their voices. Of course, they have Sohanians. They need to have the sound bites. They need to have the sound bites. They need to see the resistance. That's why they're with respect.
Don't raise you and produce your Anyway, you're making a point, Harrison.
Let me close by saying.
Yes.
Let me close by saying.
Yes.
I heard His Excellency saying there's a limited window.
It is a sin parliament, your lordships, that went against the direct court ruling. Just an example, that our policemen were not to be deployed to Haiti. We thank God they've all come back -3 or 4. Against an express order of the court, this parliament and the executive.
May I respectfully point out
This
that
is
the
an
law is
example,
limited
John.
to matters of law.
This is a matter of law, my lord. This is really a matter of law.
It's not a matter
This is decisions of the court, my lord, that have been,
He's trying to demonstrate.
I think during this
I have respect that should be
I'll
there.
be very brief, for your comfort.
Separation of power.
You give that one example only.
Yes.
Don't give any other.
Okay.
Exercise politics. So
And let me then.
after that, let him revert back to being a lawyer.
Oh my. That is what I am, my lord. I'm here in that capacity. Because we're just trying to highlight how the executive and parliament have failed to respect court decisions. And they do so with impunity, including the security laws which were ruled unconstitutional.
So my lord and my ladies, the orders by Justice Mugambi are very clear.
It is ordered under paragraph 2 that the balance of justice in favor of granting immediately an order that the status quo to be maintained until the bench, which is this bench, is in place. I think we are in agreement that the onus is on your lordships to extend these orders, and that is our plea very strongly. My learned sister Abdallah is scared that I was going to produce a CR12 to prove the point, my lord and my ladies, that Vodacom, South Africa, Vodafone, Netherlands, own 350 shares out of a total of 400 shares in Safaricom. Is it Safaricom Kenya Limited?
Vodafone.
Yeah, Vodafone Kenya
Vodacom.
Limited. Vodacom Kenya Limited. 50 shares by the Netherlands Vodafone Group and 350 shares by Vodafone. Vodacom South Africa. Therefore, Vodacom Kenya Limited, your lordships, is a completely foreign-owned company. That is the truth of the matter. That is truly the matter. To allay the fears of the chairman of CBK, I wish these very reputable international organizations will stand guided by the fact that there is a contestation about the share of these shares. I personally, on behalf of the Kenyan people, because they can get a better deal, that's for sure. In business, you don't get what you negotiate, you don't get what you deserve, you get what you negotiate. It's a negotiation issue.
Matters of law, my lord, matters of law.
So to say,
law.
no, I'm just responding to what your able chairman of CPK said.
Yes,
That was an issue which was raised.
It was raised by, yes, from the bar. Yeah, from the bar. And I have the right to respond. Because, my lord, it was expressly raised. So it must be contradicted. Because all this in an effort to make believe there is not an issue of an urgent national importance before your lordships. This is why we seek these conservatory orders. Well, even the very fact of National Infrastructure Fund, maybe for information of CPK Chair, CS Buddy is before the IMF board, just for information. And these are the issues that they are confronted with. And some of this infrastructure fund itself is subject to litigation. So my lord and my ladies, nothing, we have shown, we have proved that Parliament acted in bad faith, which is one reason why, because they went against the ruling of Justice Mugambi. My friend Muganda wanted to show one thing that goes to show this need to issue conservatory orders. Because if we don't, your lordships, we will come here and be engaged in some academic exercise when everything will have happened. We are all Kenyans. We love our country. And believe you me, we will prove, and I don't want to argue that point, because it is in our main petition, the undervaluation of the Safaricom shares. We will not allow this, your lordships, just to go unnoticed.
Therefore, I strongly urge that when you retire, to consider your ruling. You'll act in a manner, as we all know you well, justly,
and taking into account the public interest, the immense public interest. Even taking 40 billion upfront, you want to forego your own profits? What are you telling the country? My friends may want to add one or two things.
Yes, my lord, thank you very much. I have sat down here seeing my learned senior, Mr. John Ohaga, tell you that orders of Justice Mhochi were ousted or were stayed by the Korowati. That is not true. The truth of the fact is that application E14 of 2026 was heard before Justice John Mativo, Justice Gashoka, and Murungi. And they said
that they cannot stay declaratory or orders of certiorari as has been held in so many decisions of the Korowati.
So all the submissions, all the interactions made by Mr. John Ohaga should be expunged because he's representing an Attorney General contrary to orders of Justice Mhochi, which were not ousted.
What is the case number?
The case number is E014 of 2026. It's the application that was before the Court of Appeal. And if you look at the conclusion of that particular ruling by the three judges, it is clear that they declined to stay the order, declaratory orders because they are negative in nature. That is very clear.
When was that?
It was done on the 10th day of March 2026. My Lord, on jointer, we have been told that Irongo Nyakera and the governor, former governor of Nairobi, have no interest. My Lord, you cannot trash Article 22 on local standard. And secondly, Irongo Nyakera, for example, is the one who negotiated the IPO in 2007. And therefore, this is someone with a